Good morning, everyone. I hope you had a great weekend, and now we're back. Welcome back to our UFMG Summer School on Brazilian Studies 2022. And today we're having Professor Juliana Gomes. Thank you very much for coming, Professor. Such an honor to have you here with us to help us figure out this fascinating topic, which is Brazilian law. And I'm absolutely sure everyone will have a delightful morning with Professor Juliana. And now I pass the floor to you, Professor. Thank you very much once again.
Thank you so much, Luciana. It's a great pleasure to be here today. Good morning, everyone. I would like to thank everyone that is here today, but also especially the RE, because for me, it's a great honor to be part of the summer school on Brazilian studies of the UFMG. I started with this experience last year, and for me, at least, it was amazing. So I'm very happy to be here again. So let's start with our topic, that is an introduction to Brazilian law. So first, I would like to share with you a small syllabus, including what we are going to be discussing today. So first, we'll debate what is the law of the land, what we can call law in Brazil. And we will discuss a little bit the context and the roots of the Brazilian legal system. And to illustrate that, we will go through the Brazilian constitutions. As you will see, the constitutions, they have an intention of rupture to bring a new legal order into place, but at the same time, there are many elements of continuities, and that, I think, will be clear when we analyze the most important features of each one of the Brazilian constitutions until today. Our current constitution is the 1988 constitution, and we are going to talk a little bit about its characteristics, but also about the challenges that we face nowadays in terms of implementation of this constitution. So let's start. Okay, to begin with, I just want to make a brief comment on the structure of the Brazilian law. As some of you perhaps might know, the Brazilian law was historically influenced by both European and US American law. So as you'll see also in the Constitution, these elements will be present sometimes in a combination that some will call a new system, not an exact combination or mixture of these two systems, but a new one that arises from different elements taken from other countries' orders. So we have on the top a constitution that is the norm of the highest hierarchy in our system. Below it, we have statutes. We have federal statutes, state statutes, and municipal statutes. And this is something interesting. We have municipal legislatives and municipalities that are part of the Brazilian federalisms. Below the statutes, the laws in general, we have executive ordinances, resolutions, and things like that should obey both legislation and the Constitution. And then what is the place of the case law, the jurisprudence in this pyramid? Well, in Brazil, it's understood that in general, precedents are not binding. So Brazil does not adopt the idea of stare decisis, sorry. So the idea here is that the precedent has a persuasive element, but is not binding, except in some cases, and we'll see it. For example, in abstract judicial review made by the Brazilian Supreme Court. In that case, yes, the precedent, the decision will be binding for all the other branches of judiciary power and also to the executive power. But by rule, precedent is not binding in Brazil. We do not adopt the stare decisis idea. What about international treaties and conventions? So here is something interesting to discuss because that changed throughout time. So in the beginning, just after the enactment of the Brazilian 1988 Constitution, there was a debate because the Constitution brings into its text the idea of the principles of human rights. So it says, well, we bring here a lot of human rights elements, but that doesn't exclude rights coming from international treaties and human rights conventions. So some would say, well, so then all the human rights treaties are included in the Constitution and have constitutional hierarchy. That was not what the Brazilian Supreme Court adopted. Before this debate, all the international treaties and conventions were considered of the same hierarchy of ordinary legislation. But due to the peculiarities of the 1988 Constitution, as we'll see later, the Supreme Court considered that international treaties and conventions were under the Constitution, yes, but above ordinary legislation. So now the human rights treaties have a special position in our judicial order, in our legal order, between ordinary legislation and the Constitution. The other kind of treaties and conventions, not human rights treaties and conventions, they still have the same hierarchy as statutes or ordinary legislation. Okay, another interesting thing to discuss before we enter the analysis of the Constitution itself is what elements are present in this legal order. Of course, we have the text of Constitution, legislation, executive ordinances, but we also have the values that guide this interpretation, and these values are posed in our Constitution. Our Constitution is not neutral and doesn't intend to be. It points out a direction towards which the country and the nation should go. So we'll see that in more details later, but there are these values that will inform the whole legal system. Another interesting point to discuss is the interpretation of these norms. So we have the text, we have the values, we have the reality upon which these texts and values will apply, but also we have the interpretation that is made by whom. Traditionally, we tend to think about legal interpretations made by courts, but I just wanted to call attention to the fact that legal interpretation is made by everyone. Of course, due to institutional roles, some institutions and some authorities have more power in saying what is the meaning of the law or the Constitution. But we should notice that we are all the time also interpreting the Constitution. Social movements, civil society, and also, of course, legislative, executive, judiciary powers. Another challenge, and we'll again come back to that in the end, is the implementation of these text values interpreted according to a given reality. So how you take it from a piece of paper and put it into reality. What are the effects or the real effects of these legal commands and legal intentions that will be very present when you want to change a legal order, when you enact a new constitution? You can change it formally, but do you change it materially, substantively in reality? So that's something that we are going to discuss today. So As you know, Brazil became independent after being a colony of Portugal, but there are some peculiarities in this process that I would like to stress. The first is the fact that Brazil was the center of the Portuguese Empire at some point, with the royal family living here. And I'm saying that because we'll see that the first Brazilian constitution of an independent Brazilian state was not a republican constitution, as in many countries in the region. It was a monarchical constitution because we still had a king that remained in Brazilian territory when Brazil became independent. So the son of the king of Portugal stayed in Brazil and became the king of Brazil. And that is the context in which the first Brazilian constitution will be enacted. Also, we cannot forget that Brazil had slavery for a long, long time, and we'll see the consequences of that in the Brazilian legal order still today. The Brazilian state was also responsible for the genocide of indigenous people, and that is also present in our legal order. So that shouldn't be forgotten, this context of independence, of becoming a country. Another point that I would like to stress is the fact that Brazil is a very big country. It was a unitary state during the monarchy, and it remained as so after the independence, as we'll see. The monarchical power managed to keep Brazil as one single country, differently from what happened in our neighbor countries in Latin America. So let's see the Brazilian constitutions and see what they have to tell us about the Brazilian legal order and the Brazilian reality. Okay. Here I brought to you some elements, pictorial elements that show a little bit of the Brazilian history. Of course, here I'm not doing a historical presentation, otherwise I would have to point out sociological, economic, and political elements that I'm not, but I'm just bringing a political context to put into place the legal order that we are talking about. As you can see from the flags that are there, the different flags that Brazil as a country had. First, you have flags that are really like visually related to the monarchy and the emblems of the monarchical family. Then you see in the 19th century, a Brazilian flag that looks like a lot the USA flag, and that shows the US influence in Brazil at that point that will be reflected in the Brazilian Constitution. And then you will see our last and current flag that includes this motto that says order and progress. Is a positivist motto that is included in the Brazilian flag since the beginning of the 20s. So please take a last look on this slide because I'm going to the next one. Okay, so then let's talk about the specific constitutions that we had. Some will say we had 7 constitutions, some will say we had 8, and I will explain that. There I put 7, but some you are gonna see in some places 8 constitutions, and that's not a problem, okay? So let's start with the 1824 Constitution. That is the Constitution of the Independence. Okay, this Constitution is important because, as I said, it goes against the trend in the continent of having independent republics after the decolonization. It was not our case. We remained a monarchy, and that point is very present in our Constitution. When the same day our king decided to stay in Brazil and to make Brazil independence, it decided to put on constituent assembly to draft the constitution. He said he would do that in a more or less democratic, not a democracy because it was a monarchy, but in a participatory way. That was not the case. He started not to feel very comfortable with the ways that the constitution or the draft was taken, and he decided to in a way impose the draft that he was more comfortable with, the emperor. And he said at the time that the constitution should live up to Brazil and to himself, the emperor. So there are many interesting features in this constitution that I would like to highlight for you today. First, as I said, Brazil had a strong slavery present in its society and economics and all that. Despite that, the constitution would say that the Brazilian citizens were those born in Brazil, and would open the possibility of Portuguese becoming Brazilian citizens. But there was no provision for Africans to become Brazilian citizens. So you can notice that even if a former slave, as enslaved person would become free, there was no possibility of becoming a citizen, or it would be very difficult to become a citizen. As at the same time, we had this much more easier possibility for a Portuguese to become a Brazilian citizen. I should notice that at this point, Brazilian law was very much influenced by France and England of the 19th century, including the so-called separation of powers that existed at the time. So it was a monarchy, and we had parliament, and we had judiciary power. But interestingly, the emperor decided to adopt in the constitution the idea of the moderating power from Benjamin Constant, the French thinker. The problem was that when Benjamin Constant thought about this system, he thought about this moderating power as a neutral power that would provide the other branches with a harmony for them to work conjointly. The problem here was that the emperor was the one that would be the executive power, but also the moderating power. So concentrating a lot of power in its hands, exactly in the opposite way that the original idea was suggesting. So during the time, still under the 1844 Constitution, some federalist demands started to be included because we had a lot of rebellions across the country. Some will even say that the fact that monarchy was substituted by a republic was less due to a republican spirit and more due to a federalist spirit. So some scholars will point out that that important politicians that were pro-monarchy became Republicans, not because they abandoned the idea of a monarchy, but because they wanted more regional independence for the country. So in 1891, important fact, in 1888, we have the official end of slavery in Brazil. Just a couple of years later, we have the Republic, the new Republican Constitution. Some scholars will say that the Republic in Brazil has never been Republican because the ideals and the ideas, the liberal Republican ideas, were never fully implemented. At this point, there was an interesting episode just before the Republic Proclamation and just after the abolition of slavery, that was the destruction of all the registers of entrance of enslaved persons in Brazil. And at the point, that was allegedly made by an abolitionist lawyer called Rui Barbosa. And his intention was to erase this past in order not to pay reparations for former slave owners. But this episode of the Brazilian history is very ambiguous because if this destruction of documents allowed not to pay reparations to the former slave owners, it also erased an important part of the Brazilian history that were the registers of people that would come to Brazil as enslaved persons. Here, I would like to call attention to the US influence in this constitution, and this constitution is the constitution of that flag that I showed you, that is much like the USA flag. So Brazil became a federalist, adopted presidentialism, and adopted the judicial review of the laws, just as was practiced in the US. The difference here was, first, our federalism followed a different movement from compared to the US federalism, right? In the US, you had a federation of independent states that decided to come more together by, a confederation of independent states that decide to come together by adopting federalism, some kind of coordination among them, and also forbidding the possibility of separating from the country. In Brazil, the movement is the opposite. We have a unitary country that becomes a federalism. So that will leave marks in our federalism that is, until today, a more centralized federalism if, for example, we compare it to the USA federalism. Something that I find interesting to call attention to is the fact that, yes, we adopted judicial review, the same pattern used in the USA, possibly made by any judge and decided, since the Constitution was considered the top hierarchy norm. But since we didn't have stare decisis, since we didn't have the binding precedent, as I told you, these mechanisms didn't have much of relevance, because a decision that would declare a legislation unconstitutional, this decision would only apply to that case and not to the whole country, because it wouldn't be binding. So this feature, the judicial review, although it was included in the Constitution, didn't have much of impact in the Brazilian legal order. Interesting also, we have now a secular state, so church is separated from the state. As I said, we have presidentialism, and another element that is interesting, and for me also shows how they were trying to build a new order, a republican order, leave the past behind. At the same time, many elements would still be present, is that when they create the Brazilian Supreme Court at this point, many of the justices or the judges that were members of this new court were the same of the empire, the same of the monarchy. And although the Republican Constitution forbids nobiliarchy titles, the judges of the Supreme Court decide to sign the document that will found the Supreme Court with their noble names, like Duke or Baron and all that. And that's very interesting, because it's the Supreme Court that would be the ones first to enforce the new constitution and to protect the new constitution. They're much more, or at least some of them, aligned with the old order and not with the new one, signing the founding document of the Supreme Court with their empire titles. They didn't want to abandon despite the explicit test of the Republican Constitution. At this point, Brazil will leave a republic, but a very centralized republic. The republic was proclaimed by a group of members of the armed forces, and there is a lot of dispute at this time. And it's interesting that the president at the time was prosecuting the oppositors, and the Supreme Court was issuing them habeas corpus to release the adversaries of the regime. And at some point, the then president Floriano Peixoto said, well, if these guys, these justices keep giving habeas corpus to the politicians, my adversaries, I want to know who is going to give an habeas corpus to them when they will need. So a very open threat from the president of the new republic to the Supreme Court that was going against his interests. So now, at this point, we had a republic that was split between old oligarchies, mainly centered in Minas Gerais and São Paulo. And that leads to a lot of rebellious movements, especially from the military, the armed force. So at this point, you're also gonna have the stock market crash. So there is a big economic crisis. The world is going through a new moment, and Brazil will adopt a new constitution based on the claim to abandon this oligarchic republic and to modernize the Brazilian republic. This new constitution is very influenced by both the Mexican Constitution of 1970 and the Weimar German Constitution from 1919. It brings not only individual rights, but also social rights. It states that the property should be understood as necessarily fulfilling its social function. It also encompasses the female vote that began in Brazil in 1932, 2 years before this third constitution. So there are lots of advancements in terms of rights. Also, labor rights become part of the constitution. So this more welfare inspiration constitution, abandoning the old, very liberal 1891 constitution. But as I told you, many elements of the past always remain. And one of them is racism in Brazil that will be present until today. So this much praised 1934 constitution has, for instance, as one of the duties of the union, states, and municipalities to stimulate eugenics education. And that's important to point out, because many times this constitution will be praised, but it's also full of contradictions and also comprises racist elements, such as this one that I'm telling you. The problem is this constitution is also very brief, because Vargas, that was one of the leaders of this movement that gave rise to the Second Republic, so to speak, Constitution, 1934, became, with a coup, dictator in Brazil, and then enacted this new constitution, the 1937 Constitution, that was a very authoritarian constitution, inspired by the Polish constitution at the time, and also the Salazar's Portugal constitution. One of the the jurists that were one of the main drafters of this constitution was a big fan of Carl Schmitt, that was a scholar that whose ideas endorsed and gave legal basis to the Nazism. So this is a very authoritarian constitution that provides for death penalty, censorship, and the prohibition of strikes. It also states that it's forbidden for the judiciary power to decide about political issues. So it's a very broad term that will prevent judiciary power and the Supreme Court of deciding things that could be against the interest of government. And of course, Brazilian federalism in these moments of authoritarianism become much more centralized. Contradictory or not, during these moments of authoritarianism, sometimes some social rights are guaranteed, and that's the case of labor laws that advanced during the Estado Novo, during this period of authoritarianism. And there is a Brazilian historian that will say that Brazilian authoritarianism after the 30s always tries to compensate the lack of liberty with social paternalism. So guaranteeing some kind of relief or material relief, trying to compensate for the censorship, death penalty, prosecution, prohibition of strikes, and all that. So there is a labor movement that is important, but the most disruptive part of this labor movement is silenced by Vargas, that decides himself how he will discipline the labor relations. And also there is prosecution against the communism at this point. And the reason why we had this, or the alleged reason for this authoritarian state, was an allegedly, that was proven a lie later, the alleged fact that there would be communist plan to dominate Brazil. And that's why Vargas, that was the argument he used to seize power. And of course, this was proved completely a lie. And we have seen that in many countries, authoritarian leaders creating enemies to perpetuate themselves in power. And that's exactly what happened in Brazil at this time. So in 1946, we'll have first re-democratization in Brazil. And we'll see an expansion of rights. And this will follow the trend of the constitution in general in the world after the Second World War. And some scholars will say that, well, Brazil had its French and English influence. During the First Republic, we had a USA influence in our constitution. And now would be the time for the German influence, the German post-Second World War influence, a constitution in similar in some ways to the fundamental law of Bonn, the German constitution, or the West German constitution, that brings a lot of rights and values these rights in the text of the constitution. The Brazilian constitution also included social rights and labor rights. And again, the right to property conditioned to the social function and the social well-being. So this is interesting. Again, women can vote. That is kept in the constitution. Is still federalism, still separation of powers between legislative, judiciary, and executive powers, the way is mostly adopted. The only exception to that, as I told you, was the monarchy with this moderating power. And of course, during the authoritarian moments, sometimes Congress is closed. There is a lot of interference in judicial power, but formally, these three powers, the three branches, remained during the whole Brazilian history after the monarchy. So we have this short democracy during 1946 or a little bit earlier, and 1964, when we have the military coup. And here I would like to call attention to the fact that we call it a military dictatorship, but there was intense collaboration of part of the civil society that supported this coup, and also from corporations that directly benefited from this coup. So some people will call it a civil military dictatorship, and this can be more accurate because it takes into consideration this element, the support of part of the population. And here is interesting to see that although it's a military dictatorship that promotes a big rupture with the prior order, even though they don't want to abandon the legal basis for the regime, and so then they enact a new constitution, because since they were like breaching the prior law, they could just work like that and keep ruling without funding any order. But they did want to give like legal appearance to their regime. So first they issued some, as we call, institutional acts, atos institucionais, limiting the rights, allowing the prosecutions of adversaries of the regime. But then in 1967, we have this new constitution, the 1967 constitution, that is the constitution of the regime, and it limits the separation of power, the federalism, the rights, and these limitations to the rights or being expanded by these institutional acts that will, for instance, suspend habeas corpus, allow censorship, allow prosecution, forced retirement of public officials. Many members of the army itself that were contrary to this coup were dismissed and persecuted. Brazil had tortured, forced death, and all that. So this is the situation. At some point, death penalty is instituted, and this is our period of our most recent dictatorship. Then we have this process of opening that comes for several reasons. Some will defend a reading of the situation more as a negotiated pact, as the elites decided it was time to change the regime. Some will shed light not in the elites, but the role of social movements in this opening. This is disputable, the role that, which was the most important role, and some will say, emphasize the fact that this constitution was a pact, was a transitional pact, there was no rupture to bring on redemocratization. Others will point out that without the society mobilization, that wouldn't have been possible. So here it's important to have in mind that there is both of the things. And we'll see that during the process of drafting the 1988, our current constitution. I just forgot to mention something. After the constitution of 1967, the military dictatorships constitution, there was another constitution, and that's what I said, that some people will say Brazil had 8 constitutions. That was the 1969 constitution, and there is a debate if this was a reform to the prior constitution or a new constitution itself. For us here, it doesn't matter. You can count it as an additional constitution or not. It was in 1969, sorry. So at this point, many institutions that have supported the coup, including the Brazilian Bar Association, the Catholic Church, and others that in the first moment were pro-dictatorship, began to change sides. We have a labor movement, a union movement that was very important in the late 70s. One of the leaders of this labor movement was former president and current candidate Lula. We have a mobilization in the states, pro-democratization. So there are pressures for change, and Brazil starts to abandon its military dictatorship, but not in a rupture, as I said, but more in a slow process that will culminate with the National Constituent Assembly in 1987 that will write the new constitution, the 1988 constitution, that is known as the Citizen Constitution, because it's a constitution that has many rights, and we'll talk a little bit more about this. What I want to call attention now is to the fact that the Brazilian 1988 constitution is considered a progressive constitution, and it is, I'll show you. But the interesting thing that there was not much of diversity in the Constituent Assembly. 5% of the members of the Constituent Assembly that had more than 500 members, only 5% were women, 3% would be Black persons, so considered, and non self-proclaimed indigenous members. So the constitution process was not diverse in terms of the members of the Constituent Assembly, as you can see. But paradoxically or not, it became a very diverse process because social movements got really involved in this process. People traveled to Brasilia, where the constitution was being drafted, to talk with the constituents. They sent letters, they made sit-ins, they made protests. We had a lot of mobilization of different sectors of the society, and that is reflected in the constitution. Some scholars will say that this is even a problem of the Brazilian constitution because it's a compromise between very different sectors of the society, including sectors that oppose themselves. But as these scholars will say, everyone got what they wanted with the constitution. So the constitution was generous to everyone, what can become a problem because sometimes it does not define exactly its position, and will lead the debate for later for those who will interpret this document. So there are many accounts of the process of the Brazilian constitution. The political groups were mobilized. At some point, the constitution were even more progressive than in the end, but more conservatives, members of the constituent mobilized, they changed the game. So there was this big dispute inside the process, but something that is for true and that shouldn't be forgotten is the fact that social movements really participated in this process. And I want to bring the example of the women's movement. They have articulated around a motto that was constituent to be true must have women's words. So, constituinte para valer tem que ter palavra de mulher. And this was a motto that was well spread, and they managed to mobilize the so-called female caucus that was mocked by the other members of the Constituent Assembly as the lobby, the lipstick lobby. And that was, of course, maliciously used to stigmatize this group of women, the female caucus, but they decided to adopt that as a name that would represent themselves, and they have appropriated themselves of this title, of this name that was given by others, and then they became the lipstick lobby, and they managed to put some very important elements in the Constitution, especially regarding the family. Our Constitution guaranteed the parity between men and women inside the family, and that was not as it was like before the Constitution. Before that, the man was considered the head of the family, and even before that, women could not work without husband authorization, married women. So Constitution left behind all that. And also in terms of the family, it gave centrality to the rights of children and adolescents, protecting their rights. And this was also an important victory of this movement. Family planning was also included due to this mobilization of these women. They delivered to the constituents a letter from the women to the constituents, part that included many subjects, not only women's rights. Part of it was included, part was not, but it was considered a well-succeeded movement. For instance, LGBT movement was not that successful. At the time, a group of gay men were present in the Constituent Assembly to try to include. There is a clause in the Brazilian Constitution that forbids discrimination based in sex, nationality, religion, race, and so on. They wanted to include in this clause the prohibition of discrimination based on sexual orientation. They were heard at the assembly, but this provision was not included, so it was a defeat for this movement, in spite of the fact that some state constitutions that were enacted after this federal constitution did include this provision, so it was a partial defeat in a sense. The Black movement had some victories and some defeats. The defeats are related, for example, to the teaching of history of Africa and African culture in the basic school curriculum. But an important fact that was considered a major victory to the Black movement was the inclusion in the Constitution of the crime of racism that's not subject to prescription, or bail. So it was considered a very important, at least symbolic, victory for the movement at the time. Indigenous movement also participated, and some elements were considered in the Constitution. For example, the right of teaching in indigenous languages and using specific and peculiar methods of teaching in these contexts. So other characteristics of this Constitution is that it's very long and analytical, very detailed. As I said, includes sometimes different and contradictory interests. But as Roberto Gargarella, the Argentinian scholar, will point out, throughout the history of Latin American countries, it's not unusual that the constitutions or very strong in terms of rights, in terms of declaration of rights, but the organization of power doesn't follow this trend in a way that we will allow all these rights to be implemented. And this is something that we can think of when thinking in the Brazilian Constitution, the 1988 Constitution, and the challenges it presents. But briefly, just to emphasize, the 1988 Constitution is a reaction to the military dictatorship. So it brings lots of rights, including social rights, diffuse rights, for instance, environmental rights. These rights are considered entrenched clauses, meaning these clauses that can be amended, that can be changed or suppressed. In fact, it includes mentions to the International Human Rights Order, as I told you, that generated the debate around the fact if all the human rights treaties and conventions that Brazil's part would be part of the Constitution. As I told you, the answer was not, but even though these instruments have a prominent role in the Brazilian legal order, as I told you, the Constitution included criminalization of racism, free family planning and equality inside the family, affirmative actions for persons with disabilities, and other innovations. For instance, let's see some of these features. I'm moving here the slide so I can read it. So it has a very strong democratic origin that will show in the text, with this variety of rights and interests represented. The main values of the Constitution are present in its first article. It includes sovereignty, citizenship, the dignity of human person, and that's very important to be in the first article. Social values of labor and free enterprise. And here you can see that might exist a contradiction, okay? Labor interests and free enterprise interests can collide, but they are both like harmonized in this provision. And political pluralism that shows also a reaction to the authoritarian past. As I told you, some elements of the Constitution are considered entrenched clauses, and that include the fundamental rights, that includes separation of powers, that include federalism, that includes direct mandatory vote, direct secret periodical mandatory vote. And these clauses can't be suppressed. There is a debate if they can be modified, because many of them are very plastic or very open in their meaning. So they have been updated during time. And we can see that, for example, if we think of gay marriage in Brazil, the Constitution originally said, and still says, that it would consider as family entity the union between a man and a woman. And the reason for including that was to include more families, because before the Constitution, the only recognized family entity was the families based in marriage. So relationships that were not marriage, that were only cohabitation, wouldn't be considered a family in the lights of the law. And the 1988 Constitution changed that, saying that the mere union, stable union between a man and a woman would be considered a family entity and could be converted to marriage. The thing was, during the debates of the gay marriage, some people would say, well, Constitution just mentions man and woman, so that forbids other kind of relationships, same-sex relationships, to be recognized by the state. But the argument that won, and that happened in the Supreme Court in 2011, the argument that won was that the principles that guide the Constitution, or pluralistic, inclusive principles based on the dignity of the human person. And for that reason, the stable union between a man and a woman should be read as an example of a possible family formation. But others shouldn't be excluded. In fact, they should be included. And that was the reasoning of the Supreme Court decision that recognized same-sex marriage in Brazil in 2011. So it's interesting to see how the Constitution can be informally updated due to the changes of the understandings of its meanings. Of course, the Brazilian Constitution also has provisions that regulate the formal process of changing it. And we have a process of amendment that is more difficult to go through than to pass legislation, and that's a characteristic of most of the constitutions that are considered rigid, so they are more difficult to change than simply enacting a new legislation. Although it's more difficult to amend the Constitution than to pass legislation, it's not that difficult, and by now we have had more than 100 amendments to the Brazilian Constitution, and we only have 34 years of the Constitution. So it is considered a high number compared to other countries. As I told you, the immutable clause or the entrenched clauses of the Brazilian Constitution are federalism, separation of powers, and here we have combined two kinds of judicial review. As I told you, first we had this USA influence to the concrete and diffuse judicial review that can be applied by any judge. But after the Second World War, especially after the 60s, and especially with the 88 Constitution, we adopt an abstract system of judicial review, similar to, for instance, Germany and other European countries, but that got very spread around the world after the Second World War. So nowadays we combine both systems of judicial review. Any judge in Brazil can declare legislation unconstitutional based on the Constitution for a given case, and that applies only to that case. But some cases can be brought directly to the Supreme Court, and if the Supreme Court in those cases declare legislation unconstitutional, then this will apply to all the cases in the country and also to executive power. It's important that the 88 Constitution also brought the possibility of controlling the unconstitutionality of state omissions. So not only state actions, but also state omissions can be considered unconstitutional. As I told you, vote in Brazil is direct, secret, universal, and periodic, and this is also an entrenched clause. Some people will say that the fact that the direct vote is an immutable clause that wouldn't allow to Brazil to adopt, for instance, a parliamentary system, because that would encompass indirect votes. I also would like to highlight the fact that the vote in Brazil is mandatory, although nowadays we have high levels of abstention, and this is not really punished. But officially, vote in Brazil is mandatory, differently from many countries, and this is a Republican feature of the Brazilian Constitution. Also would like to highlight, since I mentioned parliamentarism, in 1993, we had a plebiscite to decide if Brazil wanted to be a monarchy or a republic, that 5 years after the enactment of the Constitution, monarchy or republic, presidentialism or parliamentarism. And Brazilian people voted and decided to keep the republic and presidential system. So that's interesting because the people really had the chance to vote on that 5 years after the enactment of the Constitution. And that also shows the compromising characteristic of the Constitution of leaving for 5 years ahead the possibility of deciding that 5 years after the enactment of the Constitution itself. As I told you, we have many individual rights and guarantees. The Constitution of 1988 also created new instruments to protect these rights. Constitutional actions before the Supreme Court as never before. Much more entities can bring constitutional claims before the Supreme Court, although individuals can't do that, but political parties, governors, associations or labor representatives, the Federal Bar Association, and many other entities can bring constitutional claims directly before the Supreme Court. The Constitution also included many so-called constitutional remedies that are actions such as habeas corpus, habeas data, injunction, mandado de injunção, and others that are actions to guarantee rights that are simplified, they are easier, they are faster, and they aim to guarantee these fundamental rights, also as a reaction to the violations of rights that occurred during the military dictatorship. So something that is important to have in mind here, I bring again our pyramid of our legal order. As you can see, Constitution, international human rights norms, legislations, decrees, ordinances. But something that I wanted to highlight here are the challenges that we still face and some authoritarian features that remained in the Brazilian Constitution. First, I would like to highlight the fact that despite the fact this is the most democratic and inclusive constitution we have ever had, it is still very timid in terms of transitional justice, in terms of social and economic rights. Of course, transitional justice is not always thought as a social and economic rights feature. Few countries have included in their transitional processes from dictatorships or authoritarian regimes to democracy, social and economic elements, but this is something important because Brazil never really dealt with its slavery past, its indigenous genocide past in terms of material reparations. So there are some provisions in the Constitution that provide for the recognition of land rights to descendants of quilombolas that were the runaway slaves that would build their own communities, and also provisions related to the recognition of indigenous lands, but they were not enough to compensate the inequalities that were built and reinforced by the Brazilian state throughout the last centuries. Another element that we should take into account is the equilibrium between civil powers and military powers. And here many scholars will call attention to the fact that militaries still have a lot of power over and influence over civilian business and civilian aspects of Brazilian life. So, and that reflects on the Constitution. For instance, some elements that are pointed out by the literature is the fact that, for example, Senate doesn't participate in the appointment for high positions in the armed forces, and that would be a way to give more transparency to this process. Also, to the fact that the armed forces still have a lot of influence in the intelligence apparatus of the state. The fact that the Constitution didn't forbid the use of the armed forces in law and order operations, in so-called atypical activities of law enforcement. So armed forces have been widely used in these operations, what puts populations in danger, what puts lots of challenges for human rights. And this is a situation that has been aggravating or escalating in the past years during Governo Bolsonaro, in which militaries are visibly part of the government and hold ministries more than they used to hold during the military dictatorship. And that that is a source of concern, because democracy theorists will call attention to the fact that a healthy democracy includes civilian control over the militaries, and these elements that we see in the Brazilian institutional design and how the politics are developing currently go in the opposite direction. We also see a reinforcement of the armed force throughout the budget and compensation policies that also are elements that scholars will call attention to as elements of lack of control of civilians over the military. So this is something that we should bear in mind, that the Constitution didn't deal completely or dealt in an insufficiently way. Another thing that I would like to call attention is that the original text of the Constitution brought lots of labor rights, and that was very important. But in the end of the list of the many labor rights that were provided for by our Constitution, there was a paragraph that would say that not all of them, in fact, most of them wouldn't apply for domestic workers. And that was also a reflect of our racist and sexist past, because domestic workers in Brazil, or in their majority, women, Black women of low-income origin, and they were not being protected by the important labor rights that were provided for in our Constitution. Fortunately, in 2013, after a lot of mobilization by the domestic workers themselves, that changed. The Constitution was amended to include domestic workers under this protection. So this was also an important change that shows how the Constitution first bring marks of its past. So it's not enough to really implement a rupture with the past, but at the same time, it can evolve, it can be updated as it was in this case in a very importantly way. At the same time, we should notice that these amendments are not always for the best in terms of fundamental rights. So we had this amendment, 2016 amendment, that was a fiscal austerity measure that wanted to control the public expenditures, but established a cap in government's expenditures for 20 years. And this amendment was very controversial, but it has been approved, and it has been affected severely fundamental rights such as health and education in Brazil. And it's interesting that the fact that this changing, or this cap, this limit to the public expenditures, was made by a constitutional amendment and not by a law or ordinary law, was because the Constitution had mandatory expenditures for health and education. So the Constitution used to go in the opposite direction, guaranteeing a minimum floor for health and education and not a cap. With this amendment, the Constitution turned out to encompass this cap for 20 years. And this is, it has been severely impacting these rights, including during the COVID-19 pandemics. So the Constitution is under dispute, constantly under dispute. Of course, not only the political changes will not always be reflected on constitutional changes. Many important changes can happen in a legal level, and we see that happening during the current government, during government of Bolsonaro. We see that many fundamental rights are being dismantled, not through constitutional amendments mainly, but ordinances, decrees. As we saw, they are under the Constitution, under the international human rights treaties, under the law, but they still can make substantive changes in reality. So it has been noticed that Governo Bolsonaro, through its decrees, has been eroding the protection of environmental rights, for instance, indigenous rights, and many others. And that, in addition to other violations of rights that we have been witnessing, including the prosecution of the government oppositors and adversaries, including professors and public servants in general. And so many scholars will point out to a current process of democratic and constitutional erosion in Brazil, in which the core values of the constitutions, the 1988 Constitution that I show you, human dignity, pluralism, and others, are being dismantled, not through necessarily constitutional amendments, but through decrees and legislation. So this graphic here that I brought shows us a little bit what is going on in a very important field that is food security. So it shows how the food security situation become very serious in the past 5 years or so. The situation, much more people living in hunger or starving in Brazil in the past 5 years. And this is result of the politics that have been adopted in the past years, including the cuts that have been made in social welfare programs. Despite that, we have other massive human rights violations in Brazil. we can talk about police brutality, we can talk about the barriers to sexual and reproductive rights, we can talk about environmental and indigenous rights. There are like plenty to be said about violations of rights in Brazil, and this is a challenge that we face. We have a very generous constitution that is not perfect, of course, as I said, and as I try to show, but we have a problem of implementing it. Of course, we have had in the past 3 decades a lot of advancements. I mentioned to you gay marriage recognition. I could also mention to you the implementation of race-based affirmative actions for public universities. I could mention, for instance, too, the recognition of persons with disabilities rights, also land rights to indigenous and quilombolas descents, as I mentioned before, freedom of expression, important decisions we also had in the past years. So we had advancements in some fields, but at the same time, at this current moment, we see a very severe setback in many fields. And I showed you a graphic about food insecurity in Brazil in the past years. And now I show you how the forests have been impacted in the past years. And this is a graphic about deforestation in Brazil. And we can also see how it has been escalating under the eyes and with the incentives of federal government. So we are living this moment right now. The constitution is in the center of the stage. We'll have elections in October, and we'll see how this is going to develop. And although we observe this conservative anti-human rights movement in federal government specifically, we have also seen resistance, not only from civil society, social movements, but also during the COVID-19 pandemic, in which federal government went against all the scientific measures. State governments and municipal governments decided by themselves to take measures to avoid the pandemic. So this was an interesting way how federalism worked to bar this kind of anti-scientific negationist approach. And the initiatives of mayors and state governments were backed by the Brazilian Supreme Court. So the Brazilian Supreme Court is still puts some obstacles to this dismantling of the human rights in Brazil, but it's a difficult game, and there are many elements in tension that have to do with our democratic process, with the protection of the institutions that are eroding in a way, and also with the protection of human rights. So what I try to show here from this brief inventory of the Brazilian constitutions is that the Brazilian constitutions, as many constitutions in the world, they were written in moments of change. They were written as documents of rupture to mean that a new order was being put in place. But the fact is that despite this intention, many of the old elements of the old orders still remain even until today. So it's also important for us to think not only in including human rights or rights in general elements in our constitution, but also to deal with transitional justice and dealing with instruments and institutions that will be able to implement and to make these changes concrete, so they don't remain only in paper. That would be it. Thank you very much.
Thank you so much, Professor. That was very insightful. We have a few questions, but I'm going to start, since you finished up talking about our constitution and how strong is our constitution. I would like to follow up on that matter, asking how close are we to a rupture of the system? Is our constitution strong enough? Are our institutions strong enough to avoid or to prevent an eventual rupture that is being promised by the federal government?
That's a very good question, but I think it's the $1 million questions. I wish I knew for sure. I would be much more chilled if I was certain that we do have a strong constitution enough to avoid any kind of rupture like that. But I would say, like, there is a Brazilian scholar called Oscar Vilhena Vieira, that he points out as an element of our constitution, the resilience of this constitution, because we have been through a lot in the past 30 years, maybe not as the threats that we are facing now, but even though a lot of changes, different governments, and the constitution resisted. He attributes that to the fact of the constitution being a maximizing pact that include the interests of many groups. But I think he has a point in a way, but I think the constitution is to be tested now. I think the biggest challenge will be now. Although I think he's right in terms of a descriptive account until now, but as we also know nowadays, the ruptures, the coups, and the threats to democracy, they don't happen, or what literature has been pointing out is that these kind of challenges to democracy don't happen in the forms of old military coups, as we saw in Latin America in the last century, but mostly with the slow, gradual deterioration of the basic pillars of democracy. And that, I think, we have been seeing in Brazil for a while, at least for the last 5 years or so. I think we are losing quality in our democracy, in our respect for our constitution. I don't know if that will culminate with a complete rupture of the constitution, or if we'll be able to fight it, or if we'll proceed in this slow process of deterioration.
Marcos, will you?
Yes,
Please.
Thank you very much, Professor. I'm going to ask a question now from Kassim Abbas. He's a student at the Lahore University of Management Science in Pakistan. And he says, as a law student in a post-colonial state, which had been under the British colonial rule, I often come across a legal order strongly influenced by concepts of utilitarianism. Most of Pakistan's codified laws are from the colonial era and demonstrate a strong subscription to concepts of philosophers like Bentham, Foucault, and Kant. I wanted to inquire if Brazil had at any point a similar philosophical influence. Do you think that the Dutch understanding and influence on legal order in Brazil will be different from the British understanding and influence on law in the Indian subcontinent?
Thank you, Marcos. Thank you so much, Kassim, for your question. It's a hard question because I wouldn't know exactly how that, and I would be very curious to know how this process developed in the Indian subcontinent, India and Pakistan, but I don't know the details of this process to compare it with Brazil. I can tell you that in Brazil, the liberal thinkers were very influential during the movement of the Republican proclamation. At that point, there was a big influence of French law, including the fact that constitutions were not considered as a proper binding rule. They were more like political charters, and they were not considered self-implemented rules, and took a lot of time for us to consider that constitution which something that will bind the state, that people can claim and use it before courts, for instance. In fact, this change only operated in the past 30 years. We have been witnessing, as in many parts of the world, a process of judicialization. Many claims are being brought before judiciary power, including claims regarding or related to rights. So, for instance, the right to health in Brazil has been judicialized a lot, and through individual claims, and there are many problems with that. On the one hand, you have the need to implement this right and to give people access to medication and treatments. On the other hand, if you do that through judiciary power, you have a problem of democratic legitimacy, and you have a problem of budget, of scarce resources, and many times people that have access to judiciary power are not the ones in most need of the society. So you can create inequality by trying to bring equality throughout the judicial adjudication of rights. Another problem with regards to that we can also observe is that this process didn't occur with all rights. So health has been a very litigated field in Brazil, but for instance, housing has not, because the courts do not recognize housing as a self-enforceable right. And it's not clear why it would be different. Health and housing and education and transport and even leisure, that is a right, is a social right under the Brazilian Constitution, and that is usually forgotten, but it's also very important. We also observe, and I think that's interesting and has to do with your question, because I think it's influence of a certain economic liberal perspective, that the Brazilian Supreme Court has been much more willing to guarantee rights of certain groups than other groups, or certain kind of rights in detriment to other kinds of rights. And I'll give you an example. We have been having protective decision before the Brazilian Supreme Court regarding, for instance, LGBT rights. This is important, and I mentioned the same-sex marriage, but we had many others. We have a very important Supreme Court decision on transgenders' right to correct their names in the documents, and so on. At the same time, we have been observing that the court hasn't been that generous with labor rights. In the opposite, it has been endorsing a process of dismantling of labor rights that are included in the Constitution. So the court is doing a very restrictive reading of labor rights, allowing to reforms that, in my view, go against the core of the labor rights in Brazil. So I think, yes, we can see the influence of some perspectives, in that case, economical liberal perspective that permeates the Brazilian law, but you have to look for it in the spaces between the lines. You have to look for it, for example, in this human rights case law and things like that. Because as I told you, we have been influenced by continental Europe, we have been influenced by the USA, we have been influenced by the movement of new constitutions after the Second World War. So we have multiple influences that in a way connect and or contradictory among themselves.
Thank you very much, Professor Juliana. We have another question from a student, Matheus Queiroz. He's a student at UFMG, and he says, Professor, Brazil has had a variety of constitutions over the years, totally on average one every 28 years. Can this create some kind of institutional instability to the point of the law being applied in the wrong way?
Okay, thank you, Marcos. Thank you, Mateus, very much for your question. I think there are two, let's unpack your question here. I think there are two things that we can discuss. The first would be, what is the law being applied in the wrong way? This is a very difficult question. What is the right way? What is the wrong way? So this is an assumption that I would challenge, because law evolves. Of course, there is wrong and right in law, of course, but you have to argue why something is right, something is wrong, and the standards that you use for that can vary. You can use as the main and the most important standard to see if law is right or wrong is justice. Does this legal order contributes to justice? If doesn't, it goes in the wrong way. I could say that. But you can also see the right and wrong implementation or interpretation of law or application of law in terms of the legal system itself. So are you applying, for example, legislation in accordance with the Constitution? Okay, then it is the right way. If you are breaching the Constitution, then it is the wrong way. So that would be a more formal approach to the problem. And this has been a whole life discussion in law. But also the second thing you mentioned is the fact that we had many constitutions, or constitutions on average every 30 years, right? Can this create some institutional instability? So this is also a difficult question, because changing constitution, of course, is something that can be very traumatic, because it's a deep process of change, and that can lead to institutional instability. But at the same time, having a constitution that's worthless, that doesn't work anymore, can also cause institutional instability. So failing to update a constitution according to the social reality can also bring institutional instability. So is there an optimal point on that? Probably there is, but also this has to do with the characteristics of the Constitution. You have a constitution such as the USA Constitution that has more than 200 years. Okay, but it's a very short constitution, very concise constitution, and a very liberal constitution. It's a constitution from another time. We have currently long constitutions. Brazilian constitution is very long, but it's not an exception. Indian constitution is very long. Bolivian constitution is very long. We have recent constitutions after Second World War constitutions that are very long, because they want to go beyond their prior constitutions, including more rights, including more people, that the short and concise constitution, by omitting, disregarded, So the thing is, there is also this debate in constitutional law that, and some authors will defend that, will defend a constitution that is very short, that only bring the procedural rules so democracy can keep going. And the decision is, we'll put in the constitution only the very essential stuff for people to decide throughout the elected representatives, throughout direct democracy, throughout vote, what they want at a given time. That could be a good idea in a way of having a long-lasting constitution. But at the same time, would we agree in what would be these basic features? Because from a liberal perspective, freedom, free speech, freedom of association, freedom of religion, or so, perhaps would be enough. From a more social perspective, I would say, well, but right to food, right to housing, to health, and to education are as crucial as these other ones to have a healthy democracy. So what are the basics? Even that would be a difficult conversation. And historically, these liberal constitutions left aside many parts, all these big blocks of the population. So I think you put a very good question, but complex question, because each of these assumptions or each one of these steps are under debate. Then they can be disputable, they can be debatable. So that would be the way I would answer your question. Maybe putting more questions than probably answer it.
Great. We still have a few minutes. I think we might have time for one more question. And my question starts by highlighting two very punctual and specific events that happened in Brazil recently. One was the case of the 11-year-old girl who was pregnant and was coerced by a judge to keep the pregnancy that was fruit of a rape, right? Fruit of a violence, abuse. And there was another case, this one is from longer ago. There was this girl, under 12, again, she got pregnant of her father, and she had the baby. The baby went through a DNA, and so there was the proof that the father was of it. She was under 12, so again, rape, and the father, incest. And the judge freed this father. So my question concerns the power of the judges going against the law, clearly, because, I mean, there's no place for discussion under these circumstances, right? I mean, there's not an interpretation of the law, right? Because, I mean, the proof was there, the girl was under 12, etc., DNA, blah, blah, blah. How can this happen? I mean, why do judges have, I mean, is the law just a piece of paper to them? What is it?
Thank you, Luciana, for your very to-the-point question. I think you are pointing out a very important problem, but I would go a step back and point out that in these cases, we have a prior problem, that is problem to access to legal abortion. That is, as you mentioned, the abortion that is already guaranteed in the law. So here we are not talking about advancing the right to abortion, but only guaranteeing the exceptions for abortion criminalization that are, as you said, rape and the risk for the pregnant woman's life, and the case of an anencephalic fetus that was decided by the Brazilian Supreme Court. So, in fact, the right of these girls should have been guaranteed when they arrived at the hospital. these cases shouldn't even be in the judiciary power. This most recent case, the girl and her mother, they went to the hospital, and the hospital refused to provide the proceeding, the abortion procedure, and recommended them, because the pregnancy was way too advanced, to go to judiciary power and have a judicial order. But the thing is, why these services aren't being provided? So I would point out two important reasons. One is because government is not guaranteeing access to abortion. And during the pandemics, the hospitals that used to provide for this procedure dropped to the half. And sometimes COVID pandemics were used as an excuse to not guarantee reproductive rights, as if they were not fundamental rights and crucial rights. So we are having a problem of access, and government has been contributing to that. For instance, publicizing a booklet, as they did like 3 weeks ago, that erroneously said that abortion was a crime in every case in Brazil. And as we just mentioned, that's not true. So government is contributing to that. The second thing is that the doctors, the physicians, or the healthcare personnel that refuse to do the abortion, they're also afraid of being criminalized. If we have this environment of misinformation and prosecution and moral panics, these healthcare professionals want to protect themselves too, because many times they are charged with crimes such as helping to conduct illegal abortion procedures. So I think then we have the problem of, when arriving at judiciary power, not being able to get the abortion because of a completely anti-rights conduct of judges, or some judges, as in the case of these girls. And also these judges probably feel backed by these norms. We had, like in 2020, the case of the girl that was raped since she was 6 and got pregnant by her uncle, and didn't manage to get her abortion procedure in her home state, that was Espírito Santo, and had to fly to Pernambuco to obtain her legal right. Just after that case, what we would think, like, government would mobilize itself to make it more viable for kids in that situation to get an abortion. But on contrary, what government did was to enact an ordinance, a Ministry of Health ordinance, creating more barriers to access to legal abortion. At the time, the barriers included mandatory notice for law enforcement authority, putting in risk this kid or this woman because they would be afraid of being criminalized themselves, because it was allegedly to report on the crime of rape. But this reporting is already done in Brazil, but not to law enforcement authority, to sanitary authorities that are in charge of this, or collecting data. That is important. But this ordinance, 2020 ordinance, created this additional barrier that can constrain and embarrass women to go to these hospitals, and also imposed other barriers, such as the fact that the woman should see the fetus in an ultrasound before opting for the abortion procedure. That later this was revoked, but the mandatory notification remained. And this is also interesting for us to see the examples how you can harm fundamental rights without changing the law, because theoretically this ordinance is just a procedural practical norm that will regulate the process before the hospital, what you have to do, who you have to talk. There will be an interdisciplinary team to take care of this woman, it should be just that, like to welcome this woman that went through a big violence. But instead of that, it's we are seeing the pyramid of the legal order is under the ordinary legislation, but it has a huge impact in the access of a right that we can say it's a constitutional right, because it's based on the right to health, right to life, gender equality, and freedom from torture. That is the case. You are torturing a kid by making her to have her pregnancy until the end. So I think you are completely right. It's very shocking how a case like that can happen, but I would just point out to the fact that it begins much earlier. It begins when you can solve the problem within the health system. That should be the place to solve it, and not bring it to the judiciary power to re-victimize this kid, to re-traumatize this kid throughout a judicial process that will take long. In the best scenario, will take long and will aggravate the situation of this pregnant child.
Yeah, sad, right? But okay, so we're approaching the end. I would like to thank you very much, Professor. It's been such an enlightening session. As I said, it was an honor to have you with us in our 2022 UFMG Summer School in Brazilian Studies. We hope to have you back next year. So thank you very much, you all, for coming. And I should just remind you of our Portuguese session in a few minutes, right, Marcos? And also, this week, we are going to have tomorrow a visit to Inhotim, the museum, virtual visit to this most beautiful modern art museum. You'll be delighted by that visit. And this will also make you want to come to Belo Horizonte to visit the museum in person. So don't forget about that. That's going to be tomorrow at 2. And also don't forget our luau on Friday at 2. Prepare your show, prepare your music or your poetry or your session, cultural session. And we are very excited to know what you are planning for us. So thank you once again, Professor. And I'll see you guys tomorrow. Let's open our microphone, our videos, so that we can see your faces. How nice.
That's very nice.
Thank you again. Bye-bye, guys. I'll see you tomorrow.
Thank you. Bye-bye.
Thank you so much, Professor.
Ciao, ciao.
Ciao.